do some introductions, tell you what we're going to do this morning, and then provide a little bit of context for this lawsuit, and then turn it over to my colleagues to talk about other aspects of this effort. So first of all, let me just acknowledge that what you're seeing here is the tip of a very large team that has been working for nearly 2 years to pull this lawsuit together. So besides the folks you see on the screen from ACLU of Pennsylvania, I'll just mention Steve Loney, Solomon Furious Worlds, Emily Hoker. We've also got John Grogan and Mary Catherine Roper for Langer, Grogan, and Diver. We've got David Radofsky and Susan Lynn from Carey's, Radofsky, Messing, Feinberg, and Lynn. We've got a large team from Deckert, led by Will Saxey and Tony Lay, and we have law professor Seth Kramer. So today, the ACLU and co-counsel filed a lawsuit in Commonwealth Court against the governor and the leaders of both houses of the General Assembly on behalf of 17 individuals who are incarcerated in 9 counties across Pennsylvania, and who are represented by either their public defender or court-appointed counsel. What they have in common is that none of them can afford to hire their own private counsel. Importantly, this lawsuit is not against any counties. It is solely against Commonwealth officials in their official capacity. How did we get here? So until recently, Pennsylvania has been one of only 2 states in the entire country that has failed to provide any state funding or oversight. The other was South Dakota. As folks probably know, thanks to Governor Shapiro, that Pennsylvania is now providing some funding in the last budget to the tune of about $7.5 million. As we'll talk about, that's a drop in the bucket, but it's a good start. The consequence of the state completely throwing up its hands and abdicating any responsibility for indigent defense is that it is an entirely county-run system. 67 separate counties providing indigent defense. Counties do not have the means to raise revenue in the way that the state does. When you look at politics, and every year budget's tight and you got to help senior citizens, you got to fund public education, roads, public health, law enforcement, you're talking about an agency, the Office of the Public Defender, that serves a constituency that has no political clout. By definition, they've got no resources. And so over the course of the last 50 years, indigent defense services have declined persistently. And when you look at it nationally, right, and you talk to folks nationally who work in this space, we are generally acknowledged to be at the very bottom of the list. If you look at a per capita spending on indigent defense, and you take out Philadelphia, which is funded differently than all the other counties, we are at the bottom, about $7 per person. We are right there with Mississippi. Now, no besmirching that state, but don't know how many elected officials are going to be jumping up and down saying, woohoo, look who we compare to. And importantly, both the U.S. Constitution's 6th Amendment and the Pennsylvania Constitution's Article 1, Section 9 create a right to counsel. That right has been in existence for more than 60 years, since Gideon versus Wainwright was decided in 1963. But importantly, the right to counsel is not just the right to a warm body with a law degree standing next to you. It requires a professional who has the time and resources to prepare an adequate constitutional defense, and they have to be able to do this at all stages of the proceedings, from the very beginning when the person is arrested all the way through plea agreements and to trial and appeal. The result of this deficient funding by all these counties is that the lawyers have overwhelming caseloads. You'll hear more about how that plays out in just a minute from Veronica. But the result is that even the most dedicated lawyers, and most of the public defenders are terrific professionals, dedicated, the best lawyers could not practice adequately with the kind of caseloads that they have to deal with. Now, why should people care about all this? So indigent defense, and by that we mean public defenders who provide the bulk of the services, but then there's also situations with conflicts. So you have court-appointed counsel for people who can't afford a lawyer. But between them, they directly represent over 100,000 people across the Commonwealth every year. And beyond sort of the harm directly to these individuals, you can multiply that manyfold because they've all got families. They've got kids, they've got partners, they've got parents who rely on them, they have jobs. And so the consequences of this is that the Commonwealth's failure to provide funding here, adequate funding, hurts hundreds of thousands of Pennsylvanians every year. Now, just very briefly, this isn't the ACLU's first foray into trying to fix indigent defense. In 1996, we sued Allegheny County in a case called Doyle versus Allegheny County, which settled with the county essentially doubling funding for that office. In 2011, we sued Luzerne County in the wake of, some folks may remember, the Kids for Cash scandal. Again, that case settled by adding some resources to that office. But all along, we've realized that the real problem is that the state has abdicated its responsibility, has failed to provide any kind of funding or leadership. And this is something that all three branches of our government know and have acknowledged, from reports by the Pennsylvania Supreme Court, reports by joint legislative executive task forces, and various other committees. And certainly Governor Shapiro acknowledged that in promoting what was supposed to be $10 million of funding eventually became $7.5. So this is a big deal. This is one of the biggest cases the ACLU has filed in a long time. It's not going to be settled or resolved overnight. It's going to take a lot of time. It's going to take all branches of government at some point working together. But we're joining ACLUs in other states like Michigan, Idaho, New York in looking at the situation. The political branches have not addressed this, so it's clear to us that we need litigation to get things moving, and that's starting today and just now as the lawsuit has been filed. So with that, let me turn it over to my colleague, R.A. Chappelle. You may not know this name, but you will get to know it soon. He is a superstar. This is the person who has really led the effort in pulling the 130 plus page complaint together. So with that, let me turn it over to Ari.
Thank you, Vic, and thank you all for joining us today. The ACLU and co-counsel on this lawsuit have spent the last 2 years digging into the indigent defense crisis in Pennsylvania. And we've observed court hearings, we've analyzed data, we've reviewed case files, interviewed public defenders and appointed counsel, and most importantly, we've spoken to dozens of people who were represented by overworked and underfunded indigent defense attorneys. And one theme that's emerged from our investigation is the sense of hopelessness that indigent people charged with crimes across the Commonwealth feel when they're represented by attorneys that don't have the time or the resources to advocate for them. We spoke to people in county jails all across the state who told us about seeing their attorney for the first time over a video screen at their preliminary hearing from the county jail. And that would happen a few weeks after their arrest, and not hearing from that attorney again until they pled guilty several months later. So these presumptively innocent people are sitting in jail without any communication from their attorneys, and they felt worried, usually with good reason, that no investigation, preparation, or advocacy was being done in their cases. Our courts have stressed that the right to counsel is one of the essential barriers against arbitrary or unjust deprivation of human rights. But when the Commonwealth of Pennsylvania fails to provide for the right to counsel, through adequate funding and oversight. Indigent Pennsylvanians, who we presume innocent in their criminal cases, are left to face the full force and might of the state without an effective advocate. The other theme that we've heard in almost every conversation we've had with public defenders and appointed attorneys was the notion of triage. Every attorney described, often with a lot of frustration, that they didn't have the time or the resources to properly handle each matter from their massive caseload. Instead, they had to triage. So triaging communications by only speaking with clients who had a hearing coming up in the next week or two. Triage investigative resources by sending an investigator, if their office was lucky enough to have an investigator, to look into the most serious cases, and triage advocacy by preparing for one trial at the expense of another. There are so many amazing public defenders and appointed attorneys that want to do right by their clients, but they simply don't have the support to do so in all of their cases. So I'm going to turn it over to Veronica Miller to share a bit about her experiences as a former public defender.
Thank you, Ari, and thank you, Vic. I have often said that being a public defender was one of the most rewarding times of my legal career. Granted, also one of the hardest, because that's what you should expect when people's lives are on the line. Driven by passion for justice, I fought alongside many dedicated and skilled attorneys, some of whom are still public defenders today. This litigation is as much about bringing to light the injustices suffered by our petitioners and the countless others like them, as it is about acknowledging the nearly impossible task of effectively representing thousands of people each year, which public defenders are routinely expected to do with little to no resources. I was lucky to have been trained by some of the best attorneys I know, and even still, no matter the skill or dedication, it cannot make up for the fact that public defenders are asked to be more than just attorneys. The clients that public defenders serve face more than just years in prison. They're challenged by poverty, mental health, substance use issues, among other things. Not only must you be a zealous legal advocate, you must also be your client's social worker, health advocate, and confidant. I quickly realized that my mounting caseload was outpacing my ability to provide each case with the attention it deserved. It goes far beyond trying to manage your workload because there are simply not enough hours in the day. Soon, it became necessary to focus on the most serious of my cases while still trying to give as much attention to the others as I could. As my colleague Ari described, triaging cases and clients becomes reflexive. At the moment, you do not realize that's what's happening, but it's what you have to do when you have preliminary hearings 2 to 3 times a week, on top of revocation hearings, bench warrant hearings, discovery to review, clients to call, jail visits to make, motions to write, and trials to prepare for. Although I was able to get favorable outcomes for many of my clients, I was constantly overwhelmed by the immense pressure to meet the standards of the representation demanded by my profession and the emotional toll of feeling powerless to change the status quo of the system I was in. The consequences of underfunding public defense are severe and far-reaching for both the attorneys and the people they represent. When attorneys are overburdened, their ability to advocate for their client is compromised. When those clients do not get the representation they deserve, it perpetuates a cycle of injustice where the already marginalized find themselves trapped in a system that does not serve them. Investing in public defense is not just about fulfilling a constitutional mandate. It's an affirmation of our commitment to valuing every member of our society. It's a reflection of our belief in equality and fairness, and recognizing that everyone deserves a fair shot regardless of their financial status.
This is Oliver from 90.5 WESA in Pittsburgh. We heard a lot about sort of the inadequate funding. Have there been any studies know anything about the outcomes of cases? Are defendants more likely to be found guilty or serve jail time in Pennsylvania? Is there a bigger discrepancy between people with public defenders than people who pay for lawyers?
All right, you want to take that?
I don't know if there's been empirical studies in Pennsylvania specifically, but I know there's been a number of studies, including one that I was looking at yesterday from Texas, that showed that appointed attorneys performed worse in the cases that they handled for indigent clients versus privately retained clients, in terms of a greater likelihood of conviction and higher sentences. So there is some empirical work nationwide, but I don't believe anything's been done specifically in Pennsylvania.
Yeah, Oliver, let me also just say that I think we've cited a study in the complaint about better outcomes for people who are represented at the preliminary arraignment. So that's at the bail stage. So, there is some evidence around that. But the other thing that we regularly see is that people who have, for instance, very low charges and have very low bail, which raises questions about whether they should have bail at all, because they must not be dangerous or a flight risk if they have such a low bail. They simply can't afford to pay that. And often we're seeing them sit in jail for months. And it's very clear to anybody who looks at the system would tell you that if that person had an attorney who had time, resources, was able to pay attention, that person would have been out almost immediately. And the same when you're trying to negotiate a plea and your lawyer has barely spoken to you, knows nothing about your circumstances, knows virtually nothing about your crime or the charges against you from speaking with you. It's hard to advocate effectively. It's hard to poke holes in the government's case. And we have an adversarial system. It only works when you've got sort of parity on both sides. So, prosecution has a lot of resources, all the police departments that they can marshal, and then you've got public defenders with their hands tied behind their backs. That does not produce just results in the adversarial system that we have in this country.
I guess I was wondering, I don't know if you've done this in other states, but when they increase the state funding in places, how do we know that like the counties don't just like lower the amount that they dedicated to defense lawyers? Has there been some sort of like, how do we know that that would actually improve the defense if they increase the state funding?
All right, you want to take that again, or?
Well, I don't know, Veronica, if you want to talk about this from the IDAC side of things.
Sure. So generally what has happened in other states that have undertaken a reform of their indigent defense system is that within the provisions of a legislative framework that is created, they put in provisions that require counties to maintain the level of funding that they have previously given to indigent defense, while also allowing the state to supplement. So there will be specific language, specifically here in Pennsylvania. There was the recent enactment and creation of the Indigent Defense Advisory Committee under PCCD, which has a grant component. And in that grant program, it specifically states that the counties may not, this funding from the state supplements and not supplants any funding. Also in other states such as Michigan, there is similar language as well. Also clawback provisions. If their standards that they have adopted are not fully enacted within each county that is receiving funds, though that commission in Michigan is empowered to be able to claw back those funds until that county then meets those standards again. So there are mechanisms to be able to ensure that the money stays there.
Do you guys have an amount in mind? I haven't had a chance to look at the lawsuit, but is there an amount that you think would be adequate? Obviously, they're in budget negotiations right now. What would they have to hit for you to be willing to drop the lawsuit?
So we have not identified an amount, and regularly what happens in these cases, and there have been other cases in states like Michigan and New York and Idaho, is that once there is a finding of liability by the court, that the state is on the hook for sort of making sure that indigent defense is provided in a constitutionally adequate fashion, that there's an assessment done to figure out exactly how much money is needed. What I will say is that a one comparator that we are looking at is Michigan, which is about the same size, similar demographics, also had a entirely county-based funding system nearly 20 years ago when the ACLU of Michigan sued there, and over the course of the last decade plus, the state funding there has gone to, I think, about $250 million. So, we don't ultimately know, but that is probably as good a comparator as we can come up with at the moment.